Ladies and gentlemen, today I've got a special treat for you. I'm going to read you the transcript from the 7th of November, and I'm going to do my best to portray each of the players in this game. So, this is in the District Court at Auckland, CRI 2017 004 005501. New Zealand Police v Mark Donald Eric Keane. The hearing date was on the 7th of November, held in courtroom 11 at 10:42 is when it started. Appearances were by Sergeant Mike McMurtry for the prosecutor, and the defendant appears in person, supported by R. Chambers as an amicus curiae. Now, I'd like to point out, he was not supporting me. She says in the transcript here, he's here to help the court. The amicus curiae, along with any other lawyer, yes, any other lawyer, is first duty is to the court, not to the client, not to the defendant, not to the plaintiff. It is to the court. They are all part of the same club. So, legal discussion before Judge Nicola Mathers.
Yes, Mr. Keane, if you want to just come forward, thank you. Do you have something?
This is my police witness in the case, ma'am, and then the officer for another case.
Yes, Mr. Keane, you filed there's a memorandum which has come to me, but I don't think that's for me. That's for the police. Is that correct?
Does it say points of clarification for court or?
Questions and clarifications for prosecution?
That's for the prosecution, Your Honour. I have one here for the court as well.
Well, it has come to me somehow, so...
Brilliant. More the merrier.
Yes, Sergeant. Are you you're in a position to proceed now?
Yes, ma'am.
All right. But I think there looks to be some preliminary matters, Mr. Keane, that you want to deal with. Do you wish to talk to a duty solicitor before we start?
I have no wish to.
So you're happy to deal with the matter by yourself?
Well, I don't actually understand what the matter is all about. That's why I'm here to find out the nature and cause of the proceedings and have fully informed plea to be entered.
When I look at the court record on the 13th of July of this year, Judge Black noted what he called a deemed not guilty plea, and the matter was remanded to today for a judge-alone trial, a defendant hearing.
Well, an objection to that, Your Honour. He did that against my intent, wishes and direction. As I was standing there holding an unsigned plea of guilty in my hand, how is it possible he could deem a not guilty plea or state I was unwilling to enter said plea?
So what do you wish to do today? Do you want...
I wish to be fully informed of the nature and cause of the proceedings. Do I have that right?
You have been charged for the particular, and I can...
Is evidence?
And I can put the charge to you again, and we can take a plea.
Is the nature and cause of proceedings listed on that charge somewhere?
It tells you what you are charged with, where it is alleged the offence took place and the date.
And the applicability, the subject matter jurisdiction or personal jurisdiction in relation to the matter? What evidence is there of that?
Well, you have been charged with you were driving in excess of the speed. That's the charge.
So is there evidence of jurisdiction?
I am not sure what to do. Just have a seat, Mr. Keane.
I think that was the gentleman that didn't get contact with him earlier.
So there is a charge, right?
Apparently so. I've received something in the post.
Did you not receive a document?
I received the document in the post. It doesn't state anywhere where the personal jurisdiction is established or any evidence of such. So what evidence? I mean, back on the 13th of July, Judge Black had stated I was presumed the subject. So what evidence of jurisdiction is there?
You were presumed what?
He said I was presumed the subject and therefore presumed that the laws of New Zealand applied. I was asking for the applicability of those cause and law without facts and evidence. There are no facts and evidence to state that.
So that's why he has entered a deemed not guilty plea. So you've answered?
Objection, Your Honour. A point of clarification. Is the judge allowed to enter a plea on my behalf?
Yes, yes.
Is he allowed to practice law from the bench?
He's not practicing law. It's the role of a judge, and if you were not prepared to enter a plea, or didn't enter a plea,
I was prepared.
then yes, the charge, a deemed plea can be entered, and that's what...
Objection, Your Honour.
Mr. Keane, just listen to me.
I was prepared to enter a plea. I was standing there holding one in my hand. So how can that be stated that I was not willing to enter a plea? How can I enter a plea without fully understanding the nature and cause?
Because I wasn't there, and this is, Mr. Keane, I was not there.
Sure, transcript.
So, do you wish to change your plea to that one of guilty today? That's what I am saying to you. What do you want to do?
Well, I wish to be fully informed of the nature and cause of the proceedings, ma'am.
You have been informed of the charge, and I will put the charge to you again.
I still have some points of clarification and questions in regards to the nature and cause of the charge.
I will put the charge to you again. You, Mark Donald Eric Keane, are charged that on the 22nd of April 2017 at Western Springs drove on the Northwestern Motorway, State Highway 16, at a speed exceeding the temporary speed limit of 80 kilometers per hour, being an offence detected by an approved surveillance vehicle equipment. Sergeant, there's no reference to a...
To a speed?
No, not a speed.
No, there's one on the original infringement. It's 94 kilometres, so...
No, it's not the speed. It's in breach of which section? There's no section or no regulation.
There is a summary of facts that accompanies that. It does... My understanding is...
Objection, Your Honour. I have no summary of facts being supplied to me, nor a witness list.
So on.
I have a brief of evidence with no mention of myself whatsoever in it, and the photograph supplied by the prosecution states recorded speed 94. 94 what? Seconds per 3 hours? I am uncertain on that one.
Well, yes, okay. Shouldn't the defendant know which particular regulation or section he's in breach of? Which I think is one of the things he's actually saying.
Yes, ma'am. My understanding is that the infringement that's sent out originally has all that information on it, and when a court hearing is requested, the charging document outlines it differently. And that's a copy of the prosecution file, including what should be a summary of facts, is disclosed. With that, and on the summary of facts, it has the regulation, section and maximum penalty. There is a letter dated the 30th of May, addressed to the defendant, outlining that a copy of the police prosecution file as at today's date, which fulfills the requirements of initial disclosure under the Criminal Disclosure Act 2008, Section 12(1), is provided within this letter. So the assumption there would be that it was included, and that's some of the facts, his history, and a copy of it.
I have the original infringement here. There is no mention of any section.
Could I have a look at it?
Of course you can.
You are happy for me to have a look at it?
Yes, you can have a copy if you wish. Can I approach?
Mr. Granger, is your client here?
Do you have that?
No.
Do you want that?
No, thank you.
You don't want?
Well, I should have had that well before now.
Yes, no, that's no.
I mean, if Your Honour chooses to carry on and accept an uninformed plea, I am more than happy to put up a defence. I have many questions, and in fact about 48 questions for the operator, and given that I caught him asleep just outside, I'm hoping he's well rested.
So is this what would have been handed to? Is that what you've been handed to, Mr. Keane?
I actually have the original document here, Your Honour. That's what I received.
Yes, that's what I'm looking for, thank you.
Would you like that?
Yes, please. As long as you're happy for me to have it.
I will require it back if I can.
Mr. Keane, I am sorry. I am just going to stand you down so I can deal with Mr. Granger's matter, and then we'll come back to you.
Of course, Your Honour, as you wish.
Sergeant, nowhere can I see where the offence is created.
I've just had a look at that. No, I can't really explain the process of that, ma'am. The infringement given out in the mail with the rights and what not for the defendant, I don't know why it's written like that, why the regulations aren't put on the infringement, but once they've chosen to defend, it's been like that for years. I mean, that's just the way it's always been. So, obviously, when they...
So, Mr. Keane, he's saying that he's...
If he doesn't know, how am I supposed to, Your Honour?
No, all right, yes.
Yes, well, yeah, essentially, once it's defended, then it becomes normal prosecution file, and the charge document is created.
But even the charge document doesn't have an offence.
Thank you, Your Honour.
But then a summary of facts is created, which does, and again, I am saying,
No summary of facts have been presented.
the assumption is that the summary of facts is disclosed. I do have a copy which outlines that for the defendant if he wishes to see it. Again, I think my assumption would be that was provided before today, but it appears it hasn't for whatever reason.
No.
So, other than that, it's that the basis of what he wants to look at, then I can provide it to him. Otherwise I guess we're running a trial on.
Your Honour, this has been going on since April.
No, I understand that.
I've waited for 4 months to return here to question the jurisdiction and the cause and nature yet again.
Well, the jurisdiction, as I said, the document is issued. You've answered the summons.
I've got something with my name on it. I came here to find out what it's all about.
And as I said, what does concern me is that there's no regulation, no section for
I move to dismiss.
Mr. Keane to know exactly what he's in breach of.
Yes, Your Honour. I appreciate, certainly, ma'am. I appreciate that. However, infringements have been issued for years and years and years under...
They may very well have been.
It doesn't make it okay.
I appreciate that may be something that needs to be looked at in the system as to why it's produced that way, but certainly it doesn't appear to have been in a raised issue before for the majority of people.
The majority will just happily pay and not question.
No, it's all right, Mr. Keane. I will come to you.
Thank you.
So I guess the, in essence, is the infringement does outline that a allegation of a speeding on a road on a certain time, date and place, and whether or not that accepted is one matter. Then the second matter is under what regulations, so if it's not accepted that...
Objection, Your Honour.
No, Mr. Keane, just...
If it's not accepted that it happened at all, then by all means we should be running the trial as per normal. If it's a matter of the defendant is not aware of the regulation it's under, we can provide that information. He can reconsider his position and then in future we could somehow look at the process being changed.
And he's also saying that he doesn't have the documentation which you're...
No summary of facts, Your Honour.
Certainly, he says that's what he's saying, ma'am, but I mean, I can only go by what's provided in the file, which says that the requirements of initial disclosure under Section 12.1. Section 12.1 implicitly states summary of facts, charging document, and criminal history.
Well, Mr. Keen's saying he doesn't. He doesn't have.
Which I haven't been supplied.
Yeah, oh yeah, I can't argue.
I can show you everything I've been supplied. There is no summary of facts. There is no previous traffic history. There is nothing like that. I have actually sent documentation to the police prosecutions on the 15th of June, 23rd of July and 3rd of October asking for these very things and not had them supplied. And in fact, only the end of October I was supplied anything from the prosecution whatsoever.
Is that correct, Sergeant?
I won't. I'm not trying to. I can't
I can supply those copies.
answer any further than what I've been given. We've been given copies of all the prosecution's documents for today and the letter that states that it's been disclosed. I don't know there's a section under the Disclosure Act and I would have to look it up.
Section 13.1.
That does distinguish the requirements of the Act. When it becomes an infringement, it's different to a criminal charge, and that's what is required to be supplied is very different in terms of obligations.
Sure, but Mr. Keen is saying that he has written asking for various documentation.
I haven't got that on my file.
You don't have that?
No.
Is this criminal proceedings held to the standard of beyond a reasonable doubt, Your Honour?
Yes, it is.
Fantastic, Your Honour.
Mr. Keen, what I'm going to do is I'm going to appoint what's called an amicus.
Amicus curiae?
Yes,
For what purpose?
to assist the court, and it won't be for today because I want...
Your Honour, I wish to have this matter ended today. I want to settle the matter. I would be happy to plead guilty if the nature and cause could be provided. It hasn't been, and I am happy to defend. Now, if you wish to accept an uninformed and involuntary plea that has already been entered by Judge Black against my wishes,
Well, I'm not going to.
then I am happy to go ahead and defend that.
Mr. Keen,
And ask Mr. as many questions as I have. But I'm not continually happy to come back here for an $80 ticket costing me over $30 personal cost each time because the prosecution can't get its facts straight or supply what I should have been supplied under Section 12.1 and Section 13.1 of the Criminal Disclosure Act. I have not had it.
right, I am going to just pause again. Mr. Granger's client is here. Mr. Keen,
Yes, ma'am.
as I said, what I would like to do is, and what I'm proposing to do, is appoint amicus curiae to assist the court, particularly in relation to the infringement offence and whether the procedure has been carried out correctly.
To what end?
To the end to assist the court and to deal with some of the matters that you are raising, Mr. Keen. The only way of dealing with it is either that we proceed with a formal not guilty hearing, that you defend the charge. If you are not in a position to defend the charge today because you say you don't have sufficient documentation, then it can be put off.
I can only go by what's supplied.
Or you enter a plea of guilty. Or you deal with the documentation that you have received if you are satisfied that you have now received everything that you've got.
What benefit would... Well, sorry, I forget your terminology. In regards to the amicus curiae, what benefit would that bring for me?
Because it means that I would be fully informed, because at the moment I am not.
Am I not to be fully informed, Your Honour?
On a legal basis, you're not a lawyer, Mr. Keen.
Exactly.
I appreciate that you're doing as good job as you possibly can, but it would mean that I would have the assistance of a lawyer, and so that would help me and you.
Would the amicus curiae assist me? Would the amicus curiae...
Of course, yes, they...
And would that amicus curiae's first duty be to myself or the court?
The first duty is to assist the court.
Thank you. So therefore he would be really on the court's side.
Assisting the court.
If the court's going to be acting fair, impartial and...
Absolutely.
Absolutely. Right, great. So there's no collusion or anything.
Normally stand up.
I would be happy to.
There would be no collusion between the lawyer and the prosecution.
I was meaning the lawyer and the court, Your Honour.
There is no collusion between lawyers and the court.
So is Your Honour to be fair, independent and impartial adjudicator with regards to this matter then?
Of course.
All right. I fail to see the point after 5 months.
Well, as I have said, Mr. Keane, you could either proceed today on a defended hearing, but you're saying that you don't want to defend the charge. You can either proceed on a guilty,
I can defend the charge.
on a guilty plea.
Well, a guilty plea would obviously require myself to be fully informed of the nature and cause, which is still not being supplied yet.
Well, the prosecution can give you a copy of the summary of facts which tells you what they're relying on.
Are they allowed to give me the information on the day straight away for me?
They can give you that information now.
Should that not have been done prior to this time?
It probably should have been, but there's still time.
Probably, or should have.
Mr. Keane, I don't want to.
I am just trying to find out the process. As you said, I am not a lawyer. I don't understand the rules.
All right, so then I will appoint an amicus curiae, and we will start from the beginning on another date.
That will cost me more time and effort to reappear. I would like to settle this matter today, so either we can continue with the defended hearing.
I will stand the matter down so you can talk to a duty lawyer, because I'm not
no wish to speak to a duty lawyer. The duty lawyer's...
I'm not here to advise you.
Objection, Your Honour. The duty lawyer's first duty is also to the court, not to myself.
That's not quite correct, Mr. Keane.
I had that confirmed from the New Zealand Law Society, Your Honour.
I can give you the opportunity of having a look at prosecution's file, and you can then decide whether you wish to continue to, whether you wish to defend the charges, or whether you wish to plead guilty, or whether the matter would be put off so we can get an amicus curiae, because I think it's highly unlikely that can do that today.
And I am confused, quite frankly, Your Honour. If I am able to be standing here defending, or to at least understand the nature and cause, should that not have been prior to now, the plea was entered against my...
The prosecution say that they have forwarded documents to you. You say that you haven't received them.
What evidence? I have not received what she showed me, the summary of facts paper that he held up, which he has not shown you.
No. So what address was it sent to?
It wasn't. I have no record of that whatsoever. It hasn't been sent to me. I have a brief of evidence.
Is that your address?
Is the postal address correct? That can be... I can receive...
So you have not received it? I accept that you have not received it.
They have not sent it. It's not that I haven't received it. What evidence do they have they even sent it to me, Your Honour?
All right. I will give...
I'm not saying something got lost in the post here. I am saying the prosecution has failed to supply me the evidence under the Criminal Disclosure Act.
I will give prosecution the opportunity for you to have a look at the summary of facts, and then you can decide what you wish to do.
I am not a lawyer. I don't understand the summary of facts. I do not speak that language.
All right. So then I will stand you down so you can talk to a duty lawyer and they can explain it to you. So I am going to give you about half an hour so that can be done. All right?
Cool. Could I get a copy of that original document back? Thank you.
Mr. Keane, yes, thank you. Was that of any assistance to you?
I spoke with the duty solicitor. I showed him what the prosecution had handed me. He threw it back on the table and said, "That doesn't mean anything. That's not evidence." I showed him the doc.
I know it's not the evidence. It's what the police are saying. That's how they're going to.
Well, he failed to explain to me.
They rely on that for their charges. Now, can I just...
He had explained to me that the infringement notice not having the details correctly written down is an abusive process. Well, it's abusive process, basically. It's basically not a legal document.
Okay, just have a seat. The notice of hearing, you have a copy of that?
That be it there, Your Honour. Yes.
My understanding in relation to section...
There's no section on here, Your Honour.
Section 21...
Of Summary Proceedings Act.
No, just turn Rule 2.1 of the Criminal Procedure Rules 2012. The notice of hearing must stipulate the section that the charge is laid under, or the regulation. Sergeant, that does not appear to be the case here, and I am obviously happy for you to have a look at. Have a look at it. But it was something that I've raised. It's Mr. Keane has also raised it in a slightly roundabout way, but he has raised it. I also refer you to, if you have a look at Form 10A in the Summary Proceedings Act, and also Section 204.
Yes, ma'am. The notice of hearing, is that a document produced by the court?
Doesn't matter who it's produced by. I'm not going to. That's...
No, I understand that, ma'am. I'm trying to kind of look at where the issue may lie.
So the infringement notice itself does not have to, but the notice of hearing does have to. So during the lunch break, you might like to just have a quick look at the procedure and what is required.
2.1? So it's 2.1 of the Criminal Procedure Act?
Well, it's 21, Section 21 of the Summary Proceedings Act 1957 for procedure for infringement notices, and Rule 2.1 of the Criminal Procedure Rules, and you also have Section 204 of the Summary Proceedings Act.
Yes, ma'am.
Your Honour, I would point out here that I have no less than 4 times from the span of May through to October, and I have highlighted here for your reference where I've stated particularly requesting for the summary of facts just to...
Sure. Thank you, Mr. Keane. What I'm going to do is give the prosecutor a little bit of time to consider the matter, because as far as he is aware, your various applications I think you handed to him this morning, so I'm going to give him a little bit of time between now and he's only got time over the lunch break.
Are you meaning the motions, Your Honour?
Yes.
All right.
So we will resume at 2:15.
Sure.
Okay.
Mm-hmm.
Right, thank you.
As your honour pleases.
And I will appoint an amicus to assist the court.
So we won't be going ahead with the defended hearing?
We will be going ahead. I am told that apparently we can. Well, all being well, we can get one. So perhaps if you can come back.
It's just the duty lawyer himself, when I was speaking to him, said there's no way I'm doing this one.
No, it won't be. No, it won't be. So if you can come back, say, at 1:30, if we can have somebody appointed to by then, do you think, and if you speak to, who should Mr. Keane speak to? If you ask, will she be there at 1:30?
Georgina Dawson, wonderful lady.
Good. If you could ask for her, and hopefully there'll be someone appointed, and you can give your documents to that person.
I would say the last time I asked for her at the criminal counter, I was rudely told that you weren't going to be dragging anyone from the office to speak to me.
All right, that's fine. She knows that you'll be inquiring, asking for her.
Thank you. Is that all at the moment, Your Honour?
Yes.
Thank you.
So, 2:15 or as close as we can. Mr. Chambers. Yes, ma'am. I was approached by the court at lunchtime. Yes. And I was happy to accept. Thank you. Have you had an opportunity of being able to have a discussion with either the prosecution or Mr. Keane as to...
Yes, I have.
You have?
We have, and sufficient for, so far as I am concerned, for the matter to proceed. Mr. Keane is ready, and I am here to assist in any way I can.
Objection, Your Honour. This man does not represent me, nor can he speak for me.
He didn't say that at all.
Oh well.
Oh well.
We've finished our discussion. We've come to court.
All right, Mr. Keane. Would you mind if I dealt with this other matter?
Not a problem, Your Honour. As you wish.
I am sorry. I know you keep being interrupted.
No need to apologise, Your Honour.
All right, thank you. Mr. Chambers, do you want to sit at...
Yes, I am quite happy to sit at the end here.
Just require 2 more minutes, ma'am, to finish the restorative justice form.
Yes, of course. Mr. Chambers, I stood the matter down for Mr. Keane's so that you could... well, so amicus could be involved. And I also stood the matter down so that the prosecution could have a look at the legislation in relation to the form of the notice of hearing and whether it was the correct form.
Yes.
And I will hear from Sergeant. I'll then hear from Mr. Keane, and if you wish to add anything...
Thank you.
Yes, ma'am. I did have a look at the Criminal Procedure Rules, Student 1, which does state the requirement under of what should be on the documents provided to the defendant. And then subsequently looked at the Summary Proceedings Act, which I've been informed has been superseded by the Criminal Procedure Act, Section 379, which essentially says the same thing as Section 204. From the Summary Proceedings Act, where no charging documents, summons, conviction, sentence, order, bond, warrant, or other document, and no process of the proceedings may be dismissed, set aside, or held invalid by any court, by reason only of any defect, irregularity, omission, or want of form, unless the court is satisfied there has been a miscarriage of justice, which in this occasion there hasn't been a miscarriage of justice for the omission of the legislative sections and act and so forth from the notice of hearing. The police file does indicate that disclosure was made to the defendant of the prosecution file.
Objection, Your Honour.
No. You can. You will have the opportunity in a minute.
And that's from a report compiled by Inspector Kelly Ryan of the Police Infringement Bureau, and outlines the documents produced being summary of facts, A4 colour photograph, notice of hearing, certificate of particulars, copy of transport notice, criminal traffic history, demerit point, suspension history, other correspondence, and the copy of the disclosure letter. It would be then that the police file indicates that the information was provided, including summary of facts, which did in fact have the legislative references on it. For whatever reason, the defendant appears today without that information.
What date was that?
That report date is compiled on the 30th of May, accompanying with that letter that was discussed earlier by the same author.
What was the date of the letter?
30 May 2017.
30 May.
30. Addressed to Mr. Mark Keane at... Some of that documentation is in the defendant's possession today. So my only assumption, for lack of a better word, would be that the rest of the information was
I don't think you can assume, Sergeant.
No, certainly, ma'am. The indication is that the information was compiled as a complete package, and therefore would be all together with the documents outlined. So, on that basis, he would have been fairly informed of the charge, as well as the section that it relates to. Notwithstanding of that, the provision of
379 of the Criminal Procedure Act, the proceedings could still be commenced, albeit with the omission, and that information of police would be ready to proceed on that basis. Mr. Keane.
Thank you, Your Honour. Now, as the prosecution has said, they received a letter from me on the 8th of May and the 15th. I would like to add, sorry, that I sent the prosecution on the 8th of May, 15th of June, 23rd of July and 3rd of October requesting certain facts, like summary of facts, witness list, previous history, demerit list. I submit that there is no way I would be asking for those things if I had already been supplied them on the 30th of May. On the 30th of May, I was simply supplied this: one cover letter dated 30th of May, notice of hearing infringement, photograph and a copy of my own email to the ticket police, and the attached letter with some questions which I never got a response from. Hence why I chased them up again in June and July and October asking for these things. He says, for whatever reason, I don't appear to have them. It's quite simple. It's because they were never supplied. It's because they never supplied them. This is the first time I've seen these documents today, and they have also asked me prior to the hearing here if I've seen other documents that they're trying to show me, which I haven't seen either.
So when you say the documents, are you holding them up? That's the summary. One of those documents is the summary of facts.
These documents were given to me by hand by the prosecution, Your Honour.
So, and I just said that's the summary of facts.
Summary of facts, demerit point list, suspension history record, criminal history, and that's 2 pages.
So you're asking for the charge to be dismissed?
I was asking to be fully informed of the nature and cause of the proceedings. I am asking for the charge to be dismissed due to the prosecution failing to supply the evidence, and given the fact I have repeatedly asked and have evidence here to support that in the form of 4 letters, I was asked what email address I sent it to. You can see on the same letter on the 30th of May, it says an email address there. That is the same email address that these were all sent to. It was only after finding a secondary email address for the prosecution service that I actually got a response to the 3rd of November. The prosecution's response was
3rd of October or 3rd of November?
3rd of October, sorry. He says, well, I can't help if you got the wrong address. Well, I am sending it to where I am told to send it. It's not for me to supply the correct contact details of the prosecution, as I have not been fully informed, and it's gone on for so long, 5 months now. Justice delayed is justice denied, Your Honour, and I would like to see this matter dismissed with extreme prejudice.
Mr. Chambers, I'm not sure whether you have had a look at the documentation, whether you have had time to do that.
I have been shown some of the documentation, and certainly Mr. Keane does confirm that he had written on the occasions that he has advised the court, and I have no doubt that this is the situation, so I am aware of that, yes.
Would you like to say anything? Any submissions?
No, I haven't, ma'am.
Sergeant, do you want to respond to that?
Yes, ma'am. If the issue now is a disclosure issue and...
Well, I think it's a combination, isn't it?
Yes, it appears to be an issue about the request for disclosure. I have seen the letter that Mr. Keane refers to, which does have the address given on the letter. I haven't seen an email chain that suggests that it was sent and bounced back, or vice versa. He probably has that information.
Objection, Your Honour. I have a copy of a response on the 15th of June from the prosecution service stating...
And what I said?
...that they have received that. Auckland.pps.office is the actual email I was getting a response from, not pps.auckland@police.govt.nz, and it's clearly just an acknowledgement letter stating that they have received the information.
And what date was that?
This is the 15th of June, so that's just for the first letter. I've received similar, although I don't think I have them here, but I can produce if required.
Yes, and as I was saying, ma'am,
I hadn't seen that response to confirm that that was the case. The last hearing, I do note, was the 13th of July, so would have post-dated that, and there's no indication on file at this end that that issue was raised last time to remedy prior to today, and if the issue is a disclosure fact on top of the rest, I would invite the court to have the matter adjourned for disclosure to be completed in full at your honour's discretion, so that the defendant is fully and fairly informed of the nature and the evidence against him before the next hearing. Certainly, as an interim measure, prior to dismissal, where dismissal is, it should be the last resort, not the first hurdle. Mr. Keane, are you happy for me to look at those requests?
Of the documents I've sent them, absolutely. I can give them if you like.
Mr. Chambers, have you seen them? Yes, I have.
I've highlighted the points where I actually am asking for information I haven't got, but also I have no witness list to date being supplied on record. The only reason I'm aware there is a witness is through a bit of trial managing to get the transcript from the 13th of July, which states that, where the prosecutor stated there was one police witness when they were arranging a fixture time and date. That is the only reason I know they have a witness. That, and I received a brief of evidence.
So, Sergeant, if you don't have any records of these documents on your... No, not on my file, ma'am, but I'm happy to concede that if there's a Gmail printout that shows that it was sent out to our office, then I am not really in a position to argue that it was sent if there's been responded to.
I've got that here. Sorry, I haven't supplied that.
But certainly, this letter with just the dates on, that doesn't appear that they were sent anywhere other than the fact that they were written out.
Would you like to see the...
Yes, thank you.
This is related to the document on the 13th of June, Your Honour. Again, it's still after the 30th of May, when I apparently had received them.
Mr. Keane, do you have any records from your computer showing that these have been...
That is it. The last document I just gave you is a printout of an email off my computer from CKA.
Yes, that's only from June the 15th.
Yes, I believe I got one also for the July and...
Do you have those?
No, as I've said, I don't have those with me. I can produce them if you require, however. That would require another time, another date, and I would prefer to have this matter dealt with and finished today.
Well, you see, what you're alleging is that you've been asking the police since the 15th of June for information.
Well, since before that, since the 8th of May.
Since the 8th of May for information which you have not received.
Correct.
I can't be satisfied that these documents have been sent. This is nothing. It's a piece of paper, all right?
Okay, does the email that I handed you at the end not confirm?
Well, that does for one of them.
Okay.
Just the same, as prosecution says they sent you the documents, you say you never received them.
Well, I can prove the email chain. I can supply that evidence.
No, I understand.
If you'd like to see that it was sent.
Mr. Keane, just listen to me for a minute, please.
Sorry.
I'm trying not to interrupt you.
I apologise, Your Honour.
I have seen what you have said. You've got some documents, so the prosecution have obviously sent you something.
Yes.
They may very well not have included the documents which you say you didn't get, and they say they sent.
Every time I get something from the police, I staple through it. So that's what I got on that date.
You're asking me to dismiss the charge because you haven't received certain information.
Yes, because I haven't been fully informed.
You are also asking me to dismiss the charge on the charge rather because the correct form has not been used.
Correct.
All right. I don't think that there is necessarily sufficient on your first aspect. Sorry, the second aspect being the correct form, all the information because you are told exactly what the charge is. It doesn't refer back to a particular section, and I have to be satisfied that there has been a miscarriage of justice. What may persuade me that there's been a miscarriage of justice, or that the charge should be dismissed, is a combination of the two, and to be satisfied about that. That you have been asking for this information over a period of time. I would like to see the email.
I can show whatever responses I had from the prosecution. I can bring that if need be.
And also what you have sent.
Sure.
So we can do that? Well, I don't think that can be done today.
Granted, which means another hearing in more time.
It does mean another hearing, it does.
Is it not? Is it not beneficial for us just to continue?
Sorry.
Is it not beneficial then just to proceed with the defended hearing and see what evidence they do have? Because...
Well, that's up to you. But you've raised these issues.
Yes, well, I haven't had the information supplied to me, Your Honour. If I asked for it, I would expect it.
I know. So, therefore, isn't that placing you in a difficult position to defend the charge by forcing you on, or are you saying I don't care?
With all due respect, Your Honour, it's not for me to defend it. It's for the prosecution to supply evidence beyond a reasonable doubt. Is that not...
Well, yes. For them to prove beyond reasonable doubt the charge.
It's not for me to provide evidence of my innocence.
You don't have to do that, no.
Right, so why would I have to supply any evidence?
I am not here to advise you what to do.
Sure.
I can ask you to talk to Mr. Chambers, but you have raised some preliminary issues, and you may very well be successful, but I don't have sufficient information to deal with what you have said today.
I can comprehend that. Thank you, Your Honour.
Okay. So, would you like to talk to Mr. Chambers?
With regards to the...
As to whether you have to come back to the court and provide the information that you say you have got to support the fact you have sent these emails. Or do you want to just say, I don't want that opportunity, I want to proceed by way of defended hearing? Because you have said you're prejudiced. So I find it a little bit difficult to be able to proceed on that basis.
Yeah, and...
So I will give you just a couple of minutes to talk to Mr. Chambers, and I know he's not your lawyer. He's here to assist me, but by talking to you and explaining perhaps in a little bit more detail, because I can't advise you.
Of course.
You might be able to sort this out.
Okay, so it's just a decision as to whether or not to proceed today, or come back once I can provide that evidence.
Yes, and what I would suggest is that if you are not successful in having the charge dismissed on the next occasion, if that's what you choose to do, that you are given the full disclosure and that you'd be ready. You'd be in a position to proceed by way of a defended hearing the next time.
Sure.
Okay.
Thank you.
Mr. Chambers, are you happy with that?
Yes, I'm happy with that.
Sergeant, you might not necessarily be happy with it, but that's what I have to do, okay? So, how long do you want? 10 minutes, perhaps?
Oh, just a couple of minutes. 2 or 3 minutes.
Yes, Mr. Keene. Mr. Chambers.
Yes, I have discussed matters with Mr. Keene. He will take the opportunity of a brief adjournment to enable Your Honour to receive the paperwork. His only additional request is that if this matter could be reconsidered preferably by Your Honour as soon as reasonably possible.
Well, I am seized of it, so...
Yes.
That's going to take a little bit of time to sort out another date.
Yes.
In the meantime, what I'm going to do, as I said, is ask the prosecution to provide you...
Full case file would be fantastic.
Well, the information that you have...
Perhaps just a disclosure order, ma'am, might be the easiest way to order it. So full disclosure in terms of...
Well, a full disclosure includes everything relevant to the case in essence. That was everything we've got. He's got too.
Yes, I think that some of the documents that you're asking for related to the 23rd of July, probably not within the prosecution's.
I can agree. There may be more than asking for than what I am allowed to.
Well, paymaster and timesheets, I don't think those are.
Yeah, well, that was more just to prove that I was an employee of the police for them to have jurisdiction. I'd like to see a timesheet too. Not to worry. Don't know if you don't ask.
Well, the police have to. The prosecution has to. Well, no, I won't say. It's up to them if they were able to prove their case or not. But some of the documents you are asking for are not relevant, or I wouldn't have thought.
I can appreciate that, thank you.
So, all documents that they have which relate to the prosecution, they need to be able to provide you with a witness list's brief of evidence.
Yes, ma'am.
What else have you got?
There?
The summary of facts. We accept the summary of facts have now been...
I have the summary of facts, the photograph, notice of hearing.
I think in completeness, ma'am, it will just get it all done to avoid doubt.
All right. So yes, the sergeant will forward all documents, all relevant documents.
Yeah, but perhaps confirmation that they had actually received those documents, because I have asked them to confirm they've received them.
Sure. No, I understand that. As I've said, that's what I want to make sure that you can confirm to me that they have been sent.
Absolutely.
How long would it take to be able to do that, Sergeant?
7 days should be sufficient, ma'am.
Now, what address should it be sent to? Or can it be done by email?
The listed address is 128 Fletcher Road, Waimaku.
Or can it be done by email or both?
Both would be preferred.
Can it be done by both email and by posting?
Certainly, ma'am.
Thank you. And that's to the address?
The email address is as I stipulate the K because the district court here seems to have missed out that when I was dealing with the transcript. So it's
Do you have copies of the documents that you have given to me, Mr. Keane? The letters?
they're all printed from my system, so I can easily make more. You're welcome to keep them.
Thank you. All right. What I'm going to do is just take a few minutes to see when we can continue, because I know my schedule is pretty full. I think it would be helpful to have matters sorted out before the end of the year, but whether that can be done, I'm not sure. So obviously, you're going to have to make sure. How many witnesses do you have?
Just the one police witness, ma'am.
Right. I have to make sure that the witness is available. Hopefully, I am not going to be too long. The date fixed. The matter can be brought back is the 9th of February. I know it's a long way away, but there is nothing, or there is the 16th of January, but I'm not sitting then. So I hope that suitable to 9th of February.
Suitable for the police.
Mr. Keane?
Fine for me, Your Honour.
So we'll make that. The matter will be adjourned for the... So we'll make that. The matter will be adjourned to the 9th of February at 9:30. Prosecution are to provide you with all disclosure by the 14th. Suitable by the 14th of November.
And I'll just print out what I've got on the computer and bring that next time, just to...
Yes.
Thank you.
All right. So we're quite clear. The issues are disclosure and the lack of, whether the notice of hearing has sufficient information.
Yes, thank you.
Other than that, it's a matter of If I say the matter has to proceed, it's a matter of putting the prosecution to the proof.
Thank you very much.
Right. Mr. Chambers, I'll ask you to, if you can, be available on that date.
I will be.
Thank you. Good. And thank you for your help. Mr. Keane, thank you. Sergeant, thank you.
Thank you, ma'am.
Thank you very much, Your Honour.